basically, like I mentioned, today we are going to follow up with the ethical and regulatory issues in audits. So before then, I would like to just give a brief introduction, just as I did yesterday and this morning. Okay, so I spoke about assurance in the first place, and I gave the two types of assurance as audit assurance and non-audit assurance. So I would like to throw emphasis on the assurance. What is an assurance? So basically, it has to do with giving a level of confidence to a financial report. So just as I explained earlier on, in every entity there is a shareholder, and in a typical entity, the shareholder do not actively participate in the day-to-day running of the business. So they always engage directors or board of directors or specifically senior management to run the affairs of the entity. And at the end of a certain period, a financial statement is prepared. So how then do the shareholders believe that whatever financial statement has been prepared is accurate? They have to invite a third person or a practitioner to give an opinion or to say something about the financial statement to indicate that this financial statement that has been given or prepared is of what? True and fair view. So basically, that is all about assurance, giving an opinion on an information that has been prepared by another party. Okay, so we mentioned specifically that with audit assurance, it has to do with giving an opinion on financial statements. So the underlying word is financial statement. If it is an opinion on financial statement, then we will term it as what? An audit. Is it okay? So these are the things we spoke about in the introductory aspect. I believe strongly you followed suit with it. Today we are going to look at ethical and legal issues, okay, or the regulatory environment of audits. And just as I mentioned, this aspect is very important as well, and it carries 10 marks. So we'll touch on some few things and reveal what is required of us whilst we are preparing for the examination. Okay, so the first thing I'd like to talk about is why must there be a need for regulations, or why must there be a need for audits to be regulated? So let me pick it from this point. Audit is very important. Why? Because a practitioner, the auditor, is giving an opinion on somebody's work. So if the auditor fails, or if the auditor makes a mistake, we can mention countless impact that will have on what? The users. So assuming that the financial statement has true and fair view, and the auditor makes a mistake and say that it has no true and fair view, okay, it becomes very, very impactful. So on that note, there is a level of public interest in whatever audit that goes into a financial statement. So because of that public interest, because there are so many users who are interested in the outcome of an audit, there is a need for it to be regulated. So once it's being regulated, then we are given the assurance that whatever the outcome may be, it is so certain that one or users can follow suit with it, or they can rely on it. So the underlying thing we can consider to be the need for regulation, it's public interest. Public interest. So on that note, we can just move ahead. So what are some of the ways that we can consider the regulation of audits? So there are two ways. We can talk about the ethical regulation, and we can consider the legal regulation. So please, let me just come back a bit. When we talk of regulation, we mean certain things that can be a guide for auditing. In fact, auditing is something very, very sensitive. And you can bear with me, in a company, as an auditor declares something or gives an opinion, it becomes very serious. And management or shareholders take it very serious with that. And how can we cannot be negligent for auditor to give an opinion which will be very forceful. So on that note, there is a very clear need for regulation. So coming back to what we were discussing, there are two ways to consider regulations. That is one, ethical regulation, and we can also talk about what legal regulation. So let me touch on the ethical regulation. With the ethical regulation, we can consider guidance from, let's say, the professional bodies. So professional body like ICAG has put in place certain regulation, certain guide for auditors to follow. Okay. Then the second one we can talk about is laws. There are laws to guide auditors or auditing in order to ensure that auditing is carried out in a very good manner. Then the last one we can mention is what? Laws coming from IFAC. So actually IFAC is International Federation for Accountants. So IFAC is actually the global accountancy body, and it regulates almost every aspect of accounting, being it the public sector accounting, auditing, mainstream accounting, any aspect of accounting. So IFAC, in a way, through the standard, International Auditing Standard Board, issues standard for regulations of what auditing. So that is one aspect. That is how we can get the ethical regulation. So three things were mentioned: professional bodies, the law, and IFAC can also issue guidance for auditing. That is one aspect. The other aspect we can talk about legal regulations. So when it comes to the legal aspect of regulating auditing, we can specifically mention the local legislation, that is the Companies Act. So once we check the Companies Act, there is a provision for the legal regulation of what auditors. Then to an extent, we can talk about the BOG's Act. So the Banking Act also provides what? An auditing regulations. It specifies what auditors should actually do for the banking or the commercial banks. We can also consider the Insurance Act. So these are all legal instruments that can be used to guide auditing. So to recap, I'll say that there are two aspects: the ethical regulation and the legal regulation. When it comes to the ethical regulation, we talk about professional bodies, we talk about the law, we talk about what? The IFAC. Then when it comes to legal regulations, specifically, it is the local regulations in specific countries. In Ghana, we can talk about the Companies Act, Act 1963, that is Act 179, the Bank of Ghana's Act, and the Insurance Act, and any other act, okay, that specifies how auditors should carry out, auditing should be carried out. Okay, away from the regulation, which gives us an overview of what we are talking about, we are going to talk about appointment of auditors. Appointment of auditors. So how is an auditor appointed, or who qualifies to be appointed as an auditor in Ghana? So specifically, guys, let me just mention this. Any company registered in Ghana here should specifically have an auditor. So the law says you should have an auditor. You should appoint an auditor. Once you fail to appoint an auditor within the space or within a period of time, the controller and the registrar general department will appoint an auditor on your behalf. So let's just take note. Once you register a company, it is important, or it is by law, for you to appoint an auditor. If you fail to do so, the registrar general on your behalf would appoint an auditor for you. So now, who qualifies to be an auditor? There are two things. The person should consent in writing to be appointed. The consent, it means that the person should accept. So anyone who qualifies to be an auditor should agree to be an auditor in writing. Then two, the person should duly be qualified. The person should duly be qualified. So when we say like an entity or someone duly qualifies to be an auditor, specifically the person should be a member of the ICAG. Is it okay? Then, or the person is an auditor, like a worker of a company that is practicing as an accountant under the what Chartered Accountants Act. Please, I hope you are getting my point. Let me just take it again. Someone qualifies to be an auditor if one, the person consents in writing. That is, if the person accepts to be the appointment to be an what auditor. Two, the person should be duly qualified. So if I say duly qualified, it's very broad, it's very vague. Who is duly qualified? That is the question we are asking ourselves. So we say if a person is duly qualified, if the person is a member of the Institute of Chartered Accountants, okay, or the person works with an auditor, and the auditor is practicing under the Chartered Accountants Act. So basically, that is it. And who do not qualify as an auditor? There are certain people that we can consider not to be duly qualified as an auditor. Okay, so one, if you are now an officer of a company, so for instance, the company is registered, they are appointing an auditor who should be considered not to be duly qualified. Not okay. One, if you are an officer of the company, okay, or you are an associate to the company, you can't what be an auditor to the company. Then two, if you are an infant, obviously, if you are an infant, if you're a kid, you can't be an auditor. Then we can also consider someone who is of unsound mind. Obviously, if you are mad, or you don't have sound mind, you can never be considered as an auditor. Then we can also consider a partner, a person who is a partner, okay, of an institution, can never be considered as an auditor. Then an undischarged bankrupt. So if by law you are you are declared bankrupt, you cannot be considered as an auditor of an institution. So let's really take note of this aspect, because a simple question can be asked that maybe a scenario is given. And with this scenario, the company registered and the company appointed an auditor. Okay, and there is an argument among the management. One side of the management is saying that the person or the entity appointed is not duly qualified, whilst maybe on the other hand, or the other parties would what argue in the fact that the appointing auditing institution qualifies. So in the examination, we can be asked, justify that on what grounds do the party qualifies to be what an auditor. Is it okay? On what grounds? So on this note, we have to just mention how the entity consents to what in writing for the appointment, and two, whether they are duly qualified. Is it okay? So when we say they are duly qualified, we should consider the fact that they are members of the ICAG, or they work with what? A private company that is registered or practicing under the Chartered Accountants Act. And on what grounds are we going to say they do not qualify, or someone do not qualify? Then we can specifically mention what? The fact that a person is an officer of the company, one. We can mention the person is an infant, two. We can also mention the fact that the person is declared bankrupt, three. The person is of unsound mind, and so on. Is it okay? All right. So let's proceed. So at what point can an auditor resign? At what point can an auditor resign? So please, I'm touching on this particular thing because it's very important. It creates a whole lot of scenarios or implications when an auditor resigns. If an auditor resigns to be an auditor of a company, it sends a signal. There are a whole lot of implications or thoughts that comes out. So on that note, let's look at the resignation of an auditor. Okay, on what grounds would an auditor resign? One, we can talk about the fact that if significant fees remained unpaid, is it okay? If significant fees remain unpaid, it's a very good ground for an auditor to resign. This thing we are saying is very, very like sensitive. You are working, an auditing firm is working for a company, and yet the company is not paying their fees. It creates a lot of implication. And maybe subsequently we'll be talking about the code of ethics. Okay, the auditor can be influenced when significant fees is unpaid. Let me give a typical scenario. So if a significant fee is not paid to an auditor, and the auditor would have to express a candid opinion in order to for public users, it may the auditor may be influenced because of that fee that is left unpaid, because maybe the candid opinion may jeopardize the company's going concern, and on that note the company may perhaps collapse and the auditor will not get his fees that is in arrears. You understand? So significant fees unpaid is a significant thing. It's a very huge issue in the area of auditing or audits, and therefore it serves as a ground for an auditor to what? Resign. All right. The second thing we can mention is what? Lack of integrity, which is demonstrated by management. As far as an auditing company is working for an audit firm, sorry, a company, okay, and the management of the company lacks integrity, then it's a very good ground for the auditing firm or the auditors to resign. Because if there is lack of integrity, it can apparently impact on the work of the auditor. Okay, now let's talk about the third one. When there is no longer independence. So independence is one key thing in auditing. So in as much as you apply yourself as auditing firm or as auditor, you need a very high level of independence. We are going to discuss independence subsequently. You are supposed to be seen independent and you are supposed to act independently. So if the audit firm has no independence or a low level of independence, then it is a very good grounds that the auditors should what? Resign. Then we can just mention on the fact that that is the fourth point. If the client is no longer profitable for the audit firm, so for instance the client is paying a very meager amount to the audit firm, and the audit firm considers that no, per the money that the audit firm the company is paying to the audit firm, the audit firm is incurring more loss compared to the revenue stream. Is it okay? On that note, the auditing firm can what? Resign. Okay, so four things have been mentioned as grounds to resign from a company as auditors. One, we mentioned the fees, significant fees being unpaid. We mentioned if there is no uh, independence. Three, we mentioned if the client company is no longer profitable to the audit firm. Then the last thing we mentioned is what? If there is lack of integrity by the management of the company, these things serve as a very good ground for the audit firm to resign. Now let's move to the eligibility of to act as an external auditors. There are two eligibilities to act as an external auditors. What when we talk about the eligibility to act as external, we are talking about the powers or the license to act as an external auditor. Okay, there are two things. One, self-regulation by the audit profession. So the audit profession, like the ICAG. Okay, ICAG is a typical audit profession. Okay, and they are mandated with what? The 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 powers to grant the license to companies or auditors to act as an external auditors. So the first we have the eligibility. The first one is self-regulation by audit profession. the audit regulatory profession like ICAG has the mandate to what? Offer professional qualifications to auditors. Is it okay? So they can as well as establish procedures for auditors to follow, and they can as well as establish or propel maybe standards or accept certain standards from the international body for auditors to as well as what to follow. Now, apart from self-regulation, the second one we can mention is regulation by government. Regulation by government. So government can also make appointments to a public institution to do regulation. So when we talk about cooperative bodies or corporate society, the government has mandated a Ghana Cooperative Society, like there is a body to serve as auditors for them. Is it okay? So on that note, that is a very clear example of how government can institute regulation. Is it okay? So let me just summarize this. I spoke about two ways of establishing eligibility to act as an external auditor. So two ways. One, self-regulation by audit profession. As we mentioned, a regulatory body like the ICAG can be what? Given the mandate to regulate auditors or to offer qualifications to auditors. Is it okay? Then two, we have what? The regulation by government. So governments can appoint a public sector institution to regulate other institutions. So basically that is it, and I believe so strongly you are following the discussion. The next thing we are going to discuss is the rights and duties of auditors. The rights and duties of auditors. Before I proceed with this aspect, especially it will give us a very good ground to talk about the duties of an auditor. Most institutions in the country, especially those that are not established, you realize that at the end of the month, you push your figures to the auditor, then you realize that the auditor will go up and down and prepare a financial statement for you. Is it okay? So most often than not, if you are not really exposed, you may think that it is the duty of the auditor to prepare financial statement, but that is very wrong. That is very wrong. It is not part of the duty to prepare financial statements for a company. What the auditor would have to do, maybe after we are done with this aspect, we would understand. What the auditor would have to do as duty is one, examine the financial statement. Is it okay? Examine the financial statement. So the financial statement on a serious grounds should not be prepared by an auditor. Is it okay? It is the mandate of the management to prepare the financial statement. Then the auditor will step in as primary duty to examine the financial statement. That is one. Then the second duty after the examination of the financial statement is to issue an audit report, is to issue an opinion on the examination of what? The financial statement. That is very key. That is very key. So two things, examine a financial statement, and the next thing is what? Issue an opinion. That is, issue an auditor's report on that financial statement that has been examined to shareholders. Okay, so now, as these things has been mentioned, let's look at how the auditor's opinion will be. What will be the auditor's opinion? The auditor's opinion is always to establish that the financial statement has true and fair view or is fairly presented. Is it okay? Then the second one is to indicate that the financial statement has been prepared in accordance with what? The applicable reporting framework. These are two things. So please, let's just keep in mind that please, let me just recap. Let me take it back again so that we may get the grounds for the discussion. So duties of the external auditor, one is to examine the financial statement. Then two, issue a report on the financial statement. So when the auditor is issuing a report, it is basically an opinion. So the opinion is that it's actually a qualification or saying something about the financial statement. That is the report. Okay. And if the auditor is saying something about a report, it is on two grounds: that the financial statement gives what? A true and fair view. So the auditor is going to state whether the financial statement has true and fair view or not. Is it okay? Has true and fair view or not? So there are two things. It's either the auditor will say it has true and fair view, or it has no true and fair view. It gives no true and fair view, or it's not fairly presented. That is one aspect of the opinion. Then the second aspect is the auditor will indicate if the financial statement is prepared in accordance to the applicable reporting framework. Let's bear in mind that the financial statement is always prepared on standard. So, for instance, we have the IFRS and the IAS to prepare financial statement. So, what an auditor will look at is to check whether in the financial statement the applicable framework or the applicable standards are well applied or are appropriately applied. Is it okay? So basically, that is it. So that is all I can say about the duties of an auditor. Then, in addition to the duties, in as much as the auditor has duties, okay, there is supposed to be certain level of rights to the external auditor in order to carry its duties. Is it okay? So we'll talk about the rights of the external auditor. One, they have access to the books of the company. Two, they have rights to all information. You can't deny your external auditor information. It is very inappropriate and unacceptable. So two, the second, as we are saying, is what? Right to all information and explanations. Then three, when there is any general meeting, they have a right to receive notice. Okay, we have right to receive notice. So if we are working in an institution and there is a general meeting and the external auditors are not invited, then meaning that that company is violating the rights of what? The external auditors. Then the fourth one we can talk about is they have the right to speak at general meetings. They have rights to speak at general meetings. So general meetings, or let's say the annual general meeting, is the grounds that the shareholders are present to look at the affairs of the company. So since an auditor gives an opinion or level of confidence to the financial statement, it is important that they get the right to what? Also speak at general meetings. Then the last one, which is a bit weird, they have the right to apply to court for directions. So subsequently, we are going to learn about a lot of things, the liabilities of an auditor, the seriousness of an external audit work, how it can cause and how it can cause people's job or people's work and how it can impact. Is it okay? So because of that sort of liabilities, okay, the auditors have been mandated with the right to apply to court for directions in relation to their what? Their work. Is it okay? So five things mentioned. They should have right to access every book or every information. They should have rights to access all the books and accounts. The second, they should have rights to access all information explanations, right to receive notice so that they can attend general meetings, right to speak at general meetings, right to apply. That is the fifth one. Right to apply to court for directions in their work. Okay, so basically that is it. So now we'll move away from the duties of the external auditor. Then we will look at the duties of management and those charged with governance. So guys, I actually gave you a gist of what management is required of in a company, especially when I started explaining the duties of an auditor. So we have a wrong notion. Most institutions have wrong notion that it is the auditor that prepares the financial statement. So at the end of the period, they just put the figures to the auditor. The auditor sits down and prepares the financial statement, and that is wrong. As I mentioned earlier, it is actually the responsibility of the management to prepare financial statement. Please, let's keep note of this. It is the duty of the management or those charged with governance to prepare financial statement. Two, when it comes to detection of fraud or prevention of fraud, it is actually in the domain of management most often than not, we presume that is the external auditor who is supposed to what? Ensure that fraud is being detected or prevented. That is very wrong. It is management. Management prevents and detects fraud. That is why management would have to appoint an internal auditor or an internal compliance person. Is it okay? All right. So the third one has to do with what? Effective control system in the organization. It is the responsibility of the the management of the company to ensure that there is a higher level of internal control in the company. Okay, so guys, I'll speak. All right, so what I would want us to discuss now is the role of regulatory bodies. Okay, or role of yeah, hello, yeah, hello. Okay, thank you. Western standard. So briefly, I'm going to introduce you to certain standards when it comes to audits. Is it okay? So I think in our earlier conversation, one key standard has been mentioned, and that standard is very key when it comes to auditing. That is the international standard for auditing. International standard on auditing. Is it okay? So there is standard. So when it comes to corporate reporting or commercial reporting, we can talk about what? IAS, that is International Accounting Standard or International Financial Reporting Standard. And when we come to the space of the public sector, we can talk about the International Public Sector Accounting Standard and so forth. But specifically to auditing, we can always attribute our level of auditing or the standard to guide auditing. Okay, so we're discussing the professional standards, of which we mentioned that the ISAs are very key. Please, we have to be very careful in quoting the ISAs because it's just like IAS. But this one, the I before the S, before the A, that is International Standard on Auditing. Is it okay? So these standards are set by the IAASB, that is the International Audit and Assurance Standard Board, which is part of what? The IFAC, which is part of the IFAC. So let's take notes. Earlier on, I mentioned that the IFAC is the Global Accountancy and Auditing Body. So the IFAC has subcommittees of which the IAASB is part. The IASB is what? Audit, the International Audit and Assurance Standard Board. And that board is responsible for the issuance or the setting of ISAs. That is the International Standard on what? Auditing. All right. So apart from the ISAs, there's also some other the standards we can talk about. Please let's take note of it. We have the ISREs, that is the International Standard on Review Engagement. Okay, that is the second one we are mentioning. Then the third one we have other standard we can talk about, which is the ISRS. Oh, okay, so we can mention the type of standards uh, as we were doing. So the ISAs, that is the International Standard for Auditing, specifically is used for the audit of historical financial information. We can also talk about the ISRE, that is the International Standard for Review Engagement. We can ask, it's purposely for what? Review historical financial statement. So remember that they are in our introductory discussion, we mentioned that uh, as part of audit related service, there is what we call review. So there is a standard when it comes to review of financial statements. Okay, and that standard is what? ISREs. Now there is also a standard on assurance engagement. So standard that is ISA is specifically for any audit other than review. Okay, any audit, any engagement other than audit or review of historical financial information. So the auditing standard is there for audit of historical information. Then the review engagement standard is also there for review of historical information. So any other assurance engagement than the audit or review, we use the what? The international standard for assurance engagement. That is ISAEs. Okay, then the last but one we can mention is what? ISRS. That is the international standard for related services. International standard for related services. So that is basically applied on compilation engagements, okay, or agreed upon procedures or other related services. Okay, so the last one we can mention is what? The International Standard on Quality Control, that is the ISQCs. It's for all the other engagements or all the other areas. So quality control is needed in all the other areas of auditing. When it comes to auditing of financial statement or historical financial statement, when it comes to review, when it comes to compilation, when it comes to agreed upon procedure, there is a need for what? Quality control. That is why there is a standard to cover all this, the other areas, and that standard what? International standard on quality control. So basically, these ones are very important because at any setting, the examiner can just pose a simple question that just explain or mention the standards, about 3 or 4 standards that you are exposed to, and what those standards are used for when it comes to the area of auditing. Okay, so with that, you have to mention any of these 5 things that have been explained here. Is it okay? All right, so I think we'll touch on corporate governance. So basically, corporate governance has to do with how institutions or companies are directed or managed. Okay, so the basis for our discussion is assurance and the fact that shareholders are not involved in the day-to-day running of the entity. So directors are mandated to run the affairs of the entity. So there is a higher need of good corporate governance. Is it okay? So corporate governance segregates what everyone is supposed to do. The role each person is supposed to what? Engage in. Is it okay? So there is actually regulations for corporate governance. So when you think the Ghana's company law or the Companies Act, it specifies certain things that we can do to protect the shareholders from losses. Okay, and there are certain guidelines as to how corporate governance can be engaged in to have a better running of the company. Is it okay? So with that, directors' responsibilities are spelled out clearly. Auditors' responsibilities are also spelled out clearly. We won't really touch on it because in our previous discussions, we've done the responsibilities of both directors and auditors. Okay, so now that what we are going to talk about, what we are going to emphasize on, is the audit committee. The audit committee. So audit committee is very important in every organization. So every organization that is concerned with systems and procedure would always establish what? An audit committee, and it's even prescribed in the code of best practices in corporate governance. Is it okay? So audit committee should comprise of at least 3 directors, majority of whom should be what? Non-executive. So always the audit committee comes from the board of directors. So number some members of the directors or the board will be taken to form a committee, which is a board committee, and we are saying that at least it should comprise of at least 3 directors, okay, and the majority should be non-executive. So if we have 3 directors forming the audit committee, 2 of them should be non-executive. Okay, Then the second point, the, the members of the audit committee should ideally comprise of directors with adequate knowledge in the field of finance, law, and in the specific industry in which the firm operates. It is very key because this audit committee will play a very major role in the organization. So, and moreover, since audits, they should have that knowledge in finance or accounting and that of what basic laws and especially the laws within which the organization is operated. Okay, the third thing we can mention about the code of best practices for corporate governance is the fact that the chairman of the committee should be a non-executive. The fourth thing is what? Always managing directors, the finance director, the internal audit head, then external audit representation should be invited to the audit committee meetings. Audit committee meeting. So what is the function of the audit committee? They recommend the appointment of external auditors. So basically, like I mentioned, every institution or entity needs, company registered needs what? An auditor, and there should be an appointment. Is the duty or the function of the external auditor to what? Recommend an external auditor. Also, that is the second one. They liaise with the external auditors to maintain audit quality, to maintain internal controls, to maintain risk assessment and all that. So basically, they are the liaison between the company and the internal auditors. They also review with the auditors the annual reports, or the auditors report on the financial statements. They do a review on what adequate systems. They also report to the board all issues of significant transactions. So, for instance, if the company wants to engage in a transaction that is way above the company's capacity and strength, it is a duty of the board to report or inform the entire board. It is a duty of the audit committee to inform the entire board about that transaction. Is it okay? And the audit committee also assists the board in developing policies. Okay, so basically that is it. These two things, as mentioned, is very key when it comes to corporate governance, and I think it has been examined before. It has been examined before for students to indicate the functions of audit committee. Or the first one, as discussed, is the composition of what the audit committee, as indicated in the code of best practices. All right, so the last thing we are going to talk about is money laundering. Money laundering is very key. So this aspect of our syllabus that we are discussing, if the examiner doesn't bring corporate governance, it's likely to bring money laundering. If it doesn't bring, it's likely to bring the appointment and all that. So let's wrap up with money laundering. When we talk about money laundering, what do we mean, or what are we referring to? Money laundering has to do with what? How criminals try to what? Hide their monies. So, for instance, in the system in which we are, Ghana, there are criminals who make proceeds or who make money out of illegal ways. And with that, they try to hide the source of funds. Is it okay? There are so many ways. Like, let's consider the fraud people we know in the system. Sometimes they make money from illegal means, or most often than not, they make money from illegal means. And what happens is that they try to conceal or hide the source of their wealth. So you will see a typical fraud person who is engaged in fraud and make returns out of the fraud. And this same person will open a boutique. Okay, you see a small boutique, and that is the boutique will be like what this person is actually engaged in, and the person will be making a whole lot of money, and the indication will be like, oh, the person is doing boutiquing or selling dress and other stuff, so it's making money. Yet there is a main source of what making money, which is what illegal and which is very fraudulent. Is it okay? So what specifically, money laundering has to do with process by which criminals attempt to conceal the true origin and the ownership of their proceeds from their criminal activities. So having engaged in criminal activities, okay, this money launderers try to what? Conceal or hide the true origin and ownership of what? The proceeds or the returns they make in their criminal activities. Okay, so we can mention a couple of them as examples like drug trafficking, terrorism. People do drugs, they get money, they try to hide it. Terrorism is a criminal activity, tax evasion, criminal activity, and fraudulent activities. Other fraudulent activities can be considered criminal activities. Is it okay? So, in as much as the an individual engages in those activities and make proceeds out of it, they are criminal activities. Is it okay? All right. So let's talk about the stages of money laundering. We have the placement, layering, and what integration. Placement, layering, and integration. So when money laundering is being staged or is being done, it goes through certain stages. We can talk about what? Placement. So this aspect, the criminals places illegal money in what appears to what? Be a legitimate business transaction. So at the first example I gave, okay, it's a typical example to what? Placement. The person makes money in illegal activity. It can be terrorism, it can be drug trafficking. Then the person will establish what? A business. Or let's say there will be a business transaction. The person will just push the money gained from the terrorism or any of the criminal activities into that transaction, and it will look as if it's making good money from those transactions. That is basically what? Placement. The second stage we can talk about is what? Layering. Layering has to do with when funds are moved through several transactions. Is it okay? So money laundering can be conducted in the layering aspect, where they move money from one aspect or one transaction to another transaction. And the transaction will be so complex for one to identify the origin of it. Then we can talk about the last one, which is what? The integration. It is the final stage of what? Money laundering. Funds are moved back into the economy to convert them into legitimate form. For instance, they make money, they push it to the first stage, second stage. Then the final aspect, they acquire properties with the money laundering money or the proceeds made from what? The criminal activities. When they acquire properties, one will think that, oh, they are making legitimate money in their legitimate business, but that wouldn't be the case. Okay, so what are the various criminal offenses connected to money laundering? So we can mention of tax evasion. We can mention of what? Retaining overpayments from customers. That is a pure money laundering. So this aspect is very crucial because a customer may engage in a criminal activity and buy from you and pay you overly or make excess payments. Once you keep it, you are engaging in money laundering. That is criminal. Okay. We can also talk about what? Payments made overseas that are deemed to be what? Bribe and what? Illegal in Ghana. So once you make payments overseas and what? It's considered to be bribe. It's considered to what? Money laundering. That falls under what? Possessing in any way, or possessing in dealing or concealing. Okay, so let me pick it. Let me pick this point again. So we are talking about the criminal offenses. One, that is possessing the process of crime. So once you possess the process of crime, you are engaged in what? Money laundering. So those things that were mentioned earlier are the ways of possessing. That is tax evasion, retaining overpayments, payments made overseas. Okay, and offenses that involves what? Saving costs. Another way of considering that can be considered as what? Criminal offense is what? Attempting or conspiracy to commit an above offense. So if someone possesses, it's an offense. If you the second point, if you attempt, okay, if you attempt to commit the above, so the attempt alone is an offense. Then the third one is what? Aiding and abetting or counseling. So advising someone to commit the first offense is an offense. So let's take note, it's not only possessing, but when you attempt, it's an offense. That is the second one. Now the third one is when you aid someone to commit such offense, it's also a criminal or a money laundering offense. The third one we can talk about is what? And any act that can constitute an offense, okay? An act which would constitute any of this offense. Then we can talk about failure by a person in the regulated sector to inform appropriate courts. So if you are working and you fail to inform the appropriate regulators about the money laundering issue, it's an offense. Then the last one is goes straight to accountants. Failure to make a disclosure which is likely to prejudice an investigation into money laundering is also what a money laundering offense. Okay, so this thing, so please let's take note of it because I think this thing has been examined before for candidates to state the various criminal offenses connected to money laundering. It is imperative to understand that it's what possessing one, then attempting to commit is also two, helping someone or aiding is also three, uh, uh, and failure to inform the regulators about any suspicion is also an offense. Then once you hide information when there is an inquiry or investigation amounts to what an offense connected to what money laundering. So aside that, the one major thing to look at, I think one of the recent sittings where it was examined for candidates to mention how money laundering can be regulated in Ghana, how money laundering can be regulated in Ghana, or is regulated in Ghana. So let's take note of the fact that Ghana is a member of what the GIABA, that is the Intergovernment Action Group Against Money Laundering, the GIABA. Okay, so the mere fact that we are part, okay, help us to fight money laundering. Okay, and also there are some regulatory frameworks that we can talk about. That is the Anti-Money Laundering Act 2008. We can also talk about the amendment to the Anti-Money Laundering Act. So the first one, Anti-Money Laundering Act 2008, that is Act 749, was actually amended in 2014. That is, which became Act 874. Okay. Then we can also talk about the AML regulations. That is the Anti-Money Laundering Regulations 2011. Then the last framework we can talk about is the 2016 amendment of what? The Ghana's Companies Act. That also helps us to fight anti-money laundering in the system. In addition to that, we can also talk about the Financial Intelligence Center, then anti-money laundering, that was established in accordance with what the Anti-Money Laundering Act. You see, okay, it also helps us to what? Fight anti-money laundering. It also helps us to fight anti-money laundering. So I think that was the last two sittings or so. So it was very clear that candidates should indicate the regulations of what money laundering, and basically these are the things that I've mentioned. That is being a member of what the GIABA, and we the institution of what the Anti-Money Laundering Act 2008 and its amendment in what 2014, and as well as the regulation anti-money laundering regulations and that of what the 2016 amendment of what the Companies Act. The fact that we have the establishment of the Financial Intelligence Center helps us to what, fight anti-money laundering. Okay, so the last thing I'll talk about is the obligations placed on professional firms. Okay, the obligation placed on professional firms. So in the fight against money laundering, professional firms have certain requirements. One, they are supposed to put in place systems, controls, okay, so that if their firms will not be used as money laundering purpose. Sometimes, because a professional firm, people are dissuaded from the fact that they can be engaged in money laundering. And for that reason, money launderers can just use them in their money laundering process. So there is an obligation placed on these professional firms, could be auditors or any other professional company, okay, to put in place system controls to ensure that they are not used for money laundering. Two, they have to appoint anti-money laundering or money laundering reporting officers to ensure that like any sort of suspicions of money laundering are reported. Third, we can talk about establishment and enhancing good record keeping system so that all transactions can be traced. We can talk about the fourth one, which is establishing procedures within the firm for reporting any suspicion. Then the last one has to do with training and educating staff. Training and educating staff is very critical. It is very important in the obligation placed on firms. So this is very key because similar question can be asked that an audit firm or a professional firm has been indicted on as being part of the money laundering process. So what could be the justification to get away from the accusation? So what could be what is required of the audit firm that they kept in place, okay, which will serve as a defense against that allegation. So it's just the same as we have discussed in the obligations placed on professional firms. So the fact that you put in place systems, the fact that they appoint money laundering reporting themselves, the fact that they establish and enhance record keeping systems, the fact that they establish procedures within a firm to report money laundering, the fact that they train and educate staff on money laundering issues, it is a very good justification as a requirement they actually kept in place to ensure that there isn't any money laundering activities. So guys, thank you very much for your attention. It has been a wonderful time talking about the regulatory aspect of auditing. That is just a part of it. In our subsequent meetings, we will have time to digest and complete every aspect of the regulatory environment so that it will be very good to fix the examination. Thank you for joining the discussion, and I wish you all the best. I'll be available to discuss any thing you have in mind, any question you want to pose. Then we'll pick it up from there. Thank you and have a wonderful evening. Bye.